The American legal system is composed of many distinct parts: federal and state governments, laws, and courts. Federal law exclusively governs some areas of the US legal system. Other areas depend on the subtle nuances of state law. Some parts of the legal system are based on written laws called statutes or codes, which are developed by governments. Other areas of the law depend on principles developed from years of legal traditions and court decisions. There are two main types of laws. Civil law provides the resolution of disputes between private individuals, organizations, or governments. Criminal law governs the prosecution of those charged with serious offenses against public order, such as murder. The US Constitution calls itself the supreme law of the land. It is the fundamental authority for the American federal system of government. The legislative branch makes the laws, the executive branch enforces the laws, and the judicial branch reviews the laws to make sure that they are constitutional. This is the checks and balances system that describes the relationship among the three branches of the federal government. The lawmaking authority of the legislative branch of the federal government is outlined in Article 1 of the Constitution. Collectively, the legislative branch is called Congress. The US Congress consists of two chambers, the US Senate and the US House of Representatives. Congress has the power to enact laws that are necessary and proper for carrying out its duties. Article 2 establishes the power of the executive branch of government, which is led by the President of the United States. The President has the power to enforce the laws of the United States and has the responsibility of maintaining the day-to-day operations of the US government. The President also has the power to sign or veto any legislation that Congress passes. Article 3 of the Constitution establishes the judicial branch of the federal government. This article vests the judicial power of the United States in one Supreme Court. The US Supreme Court is the highest court in the country. Congress has the authority to determine the actual number of Supreme Court judges. Currently, there are 9. The Constitution requires that all Supreme Court justices, similar to all federal court judges, be appointed for life for a simple reason: to help promote an independent judiciary. They cannot be fired if their decisions are unpopular or not favorable to a particular political party. The Constitution specifies the basic lawmaking process. A bill is the initial draft of a potential law. Once a bill is introduced, it is assigned to a committee which meets to discuss, amend, and vote on it. Both chambers of the Congress must approve the same bill, and the President must sign it before it becomes a law. The Speaker of the House of Representatives and the President of the Senate sign all bills that pass in Congress before delivering them to the President. The President has 10 days to sign the bill. If the President does not sign it within 10 days, then it becomes law, just as if the President had signed it. It then becomes an act of Congress, a federal law. These are published in the United States Code, available at this link. Interestingly, the Cyber Fraud and Abuse Act, the CFAA, which is a big law in the domain of cybersecurity that punishes fraud is also available at the same link. Jurisdiction describes the types of cases that a court has the authority to hear. There are three main types of jurisdictions. Original jurisdiction, this is the power of a court to hear the initial dispute between parties. These courts conduct trials. Usually trial courts have original jurisdiction. Concurrent jurisdiction is jurisdiction that is shared by several different courts. An appellate jurisdiction is the power of a court to review a decision made by a lower court. District courts are the lowest level of courts in the federal court system. There are 94 judicial districts in the United States. The district courts are the workhorses of the federal judicial system and serve as courts of original jurisdiction. The next level of courts is the intermediate appellate courts. In the federal system, these courts are called the U.S. Courts of Appeal. There are 13 courts of appeal. The highest level of court in any judicial system, state or federal, is often called a court of last resort. The highest court in the U.S. federal system is the U.S. Supreme Court. A party has to ask the Supreme Court to review the case via a petition. Under the Constitution, powers that are not specifically granted to the federal government in the Constitution remain with the states. State governments existed before the federal government as we know it today. Similar to the federal government, most states are organized under a constitution which may vary widely from the US Constitution. Most state legislatures resemble the legislative branch of the federal government. A governor leads the state executive branch. The state judicial system looks similar to the federal system with a court of trial courts, appellate courts, and courts of last resort. The federal government delegates some regulatory and enforcement functions to administrative agencies. Typically, these are subject matter expert agencies. These delegations are made because it would be impossible for Congress to make timely laws in some of the many different areas that are regulated by the federal government. Now, agencies may have many different functions. For example, many of the laws in the United States are actually administered by regulatory agencies. These agencies create rules, enforce compliance, and hand out sanctions within their specified area. One such independent federal agency is the Federal Trade Commission, FTC. Its mission is to promote consumer protection and eliminate practices that are harmful to competitive businesses in many areas of the economy. The doctrine of precedence is one of the most important traditions in the American legal system. This doctrine means that courts will look at the decisions made in these prior cases to determine the appropriate resolution for new cases. A case of first impression is a case for which there is no precedence. These cases raise a legal issue that has never before been decided. However, there will be many cases where a precedence does exist. For example, the US Supreme Court is the final authority on cases heard in the federal court system. If other lower courts in the federal system have a new case that concerns an issue that the Supreme Court has already addressed, those lower courts are required to follow the law as it was interpreted by the Supreme Court. State courts also must follow the decisions of the US Supreme Court to the extent that the state court is reviewing issues that include US constitutional or federal law. The doctrine of precedence is not absolute. Precedents can change when it is apparent that a society's values on a particular issue have changed. Overturning precedents is a milestone event for the law because it changes established legal principles. A landmark court decision is a decision that establishes new precedents. Some famous examples include Brown versus Board of Education, a landmark 1954 Supreme Court case. The court ruled unanimously that racial segregation in public schools was unconstitutional. And then Roe versus Wade, a 1973 Supreme Court case that legalized abortion in the United States.